Okay, we might get started. It's 11:30 now. Hello, everyone. Welcome to session 2 of the 8 Frontiers of Environmental Law Colloquium. Today, for our midday panel, we've got the topic being global law and the challenges of the Anthropocene. And so we've got quite a range of papers from some very interesting scholars, and they're all centered around this idea of the challenges that we might face in the future when it comes to the Anthropocene, and also perhaps some of the opportunities that might come along with those challenges. In terms of the structure for today, each presenter is going to have 15 minutes for their paper. I'll give them a reminder when it gets to 10 minutes, and then 14 minutes so that they're aware of the time, because we want to make sure that there's about half an hour at the end for questions. In terms of questions, for the viewers, if you'd like to leave your questions in the Q&A box, and then in the last half an hour of the session, we'll address all the questions to the panelists together, and we'll see if we can get some discussion going. With that being said, I guess we'll start with the first panelist, which is Inji Johnston. Inji is a barrister and solicitor at the High Court New Zealand and a PhD candidate at Victoria University of Wellington, where she researches net zero as a norm bundle within international environmental law. Inji has a keen interest in climate change law and trade climate nexus, which she's developed as a Fulbright scholar and young leader at the Global Centre on Adaptation. Her career to date has spanned 4 continents and includes positions in a range of environment, NGO, and IGO settings. She holds an LLM in natural resources, environmental and energy law from the University of Colorado Boulder, and LLB honours from Victoria University Wellington, and a Bachelor of Science in Physical Geography Economics from the University of Otago. And Inji's presentation is entitled New Norms at the Frontiers of International Environmental Law. So I'll hand it over to you, Inji, and to share your screen and kick us off.
Oh, thank you, Ethan. Right. Brilliant. Is that all working for you guys? Fantastic. Great. So kia ora koutou, everyone. My name is Inji, and I'm a PhD candidate at Vic. As Ethan has said, I'm speaking to you currently from my base in London at the moment, where it is well past my bedtime. So please excuse me for that, but I'd really like to thank the organisers for their work today. And so this presentation is really intended to kind of spark a conversation about new norms at the frontiers of international environmental law. And I'd like to start with just a bit of a preface that obviously, due to the time constraints, this isn't going to be, a comprehensive overview, but I really hope it's an area that you'll find interesting, and one that I look forward to hearing your thoughts on at the end of today's presentation. So to kick us off, as a bit of a primer, I first want you to kind of think about what you think of norms of international law. And so, for example, you might think of norms of general international law, like the sovereign equality of states. But having had focus on environmental law, you might also be thinking about international environmental law norms, such as sustainable development, common but differentiated responsibilities, the precautionary principle, polluter pays, etc., etc. But what's clear, whether you're thinking about norms generally or specifically, is that the substance of these norms is essentially known, but at the same time, there's actually very little clarity or consensus about whether such norms are actually can be considered legal norms. And this is because both the sources that contribute to them and the scope and application can actually be up for debate and a lot of contestation. And the reason why that is that putting substantive considerations aside, we forget that the secondary rules of norms are actually at play. And these are norms of international lawmaking. And so these are the kind of norms that, as I mentioned, kind of instantiate our legal discourse about how we think about norms emerging, evolving, and ultimately kind of decaying as well at the other end of the spectrum. And so actually what's interesting is this step comes before thinking about substantive new norms, because they actually frame the kind of sources we consult to look for evidence of new norms, the range of actors we see having a role in new norms, especially the role of non-state actors or international organizations. It also informs our decision-making about the kind of typologies of norms, rules and principles, and also crucially, the ultimate impact that such norms could have, for example, whether it is possible for them to be legally binding. And so these kind of norms of international lawmaking are really norms in a procedural sense. And so the reason why I'm kind of talking both about them today is that in my presentation, I'm kind of going to be covering aspects of both. And so it's a distinction that I kind of want you to keep front of mind when we go through this. So to kick us off, really I'm presenting today as some 10 considerations of what I'm terming the new norm of norm making. And where I think it's useful to start is really thinking about the impetus for this research project, which is just the increasing gap between the practice of law and just the practice of how we think about the law. So I like kind of beginning with the fact that like a lot of the traditional theory of norm emergence actually emerged right after the two world wars. So we had right in 1920, there were significant developments. But obviously these kind of developments of thinking about sources of law were crystallized, as we all kind of know, into the International Court of Justice's statute. And this was agreed on the 26th of June, 1945, which for the history nerds among us will know that it's only a month after V-Day. So it was agreed in this really kind of tumultuous time of world politics. But it's still really crucially looked at as a kind of main source of how we conceptualize sources of international law and ergo sources of international norms. And so the categories that it sets out are things like treaty, custom, general principles, and subsidiary means such as judicial decisions, as well as the teachings of the most highly qualified publicists. And this is back then what I kind of outline as called the canonical outline. But the issue is that over the past 75 years, we've really seen a proliferation of norms, and both norms of a general international law nature, but also specifically to environmental law. And so we've seen waves of scholarly thought really delving into how one might approach new norms, for example, the balance of state practice in opinio juris. But even since the most recent of these kind of iterations at the end of the 20th century, the actual practice of international law has changed quite considerably. We're no strangers to the fact that everything around us is globalized and the law is the same. And so what was once these kind of canonical outlines in Article 38, I now posit are probably canonical confines in a lot of respects. And so this has kind of led to this disconnection between the practice of law and the practice of thinking about the law. And it's just important to consider why there's this important question. Well, what's quite interesting is when we compare international law norm research with that of international relations, we find that international relations scholars don't have that same kind of fixation about finding out whether it's essentially a legal norm. They're just kind of interested in that practice and how it affects states and other actors. But for us lawyers and scholars of international law, it still remains a really important question. And it remains an important question because there's, as Brune and Toop put it, there's a really distinctive sense of legal legitimacy that legal norms carry. And that in turn leads to this practice of legality that's really important when considering what makes a legal norm legal. So why this is important for the purposes of today is that this is especially true for international environmental law. So as we all know, environmental law grapples with a wide range of issues, and we're fortunate that many of those are on display at this conference. Now, what links these kind of areas together, from the deep sea to air pollution, genetic modification, all of the above, is that they're really linked to science. And so we've often seen that new specialisms of international environmental law really evolved to match the new problems that we see. And we saw this, for example, in the Montreal Protocol. And because of this way of developing, international environmental law is really inherently dynamic, and it has interlinking aspects throughout energy, trade, investment law, property law. And for this reason, unlike other areas of law, it really kind of defies these traditional legal boundaries set down by the ICJ. And what's quite interesting is that this can actually be understood because when the ICJ was founded, obviously we had some environmental law cases like trail smelter, but often at the time that environmental law was thought of as a bunch of tort law, nuisance law. And so it was not really seen as this kind of distinctive subset of legal problems that also really involved science and finding that solution. But the ICJ actually did recognize this in 1993 when it set up its own environmental chamber to kind of get that specialist input. But the reason we haven't really heard of it is because it actually disbanded in 2006 without ever hearing a case. So I think this is a really good example of how clearly this disjunct is between, again, the practice of international environmental law and a practice of thinking about international environmental law conceptually. So to really concretize why this is important, I'm going to turn now to an example of a source of new norms, which is net zero. And so I posit here that net zero as a potential source of new norms really does defy legal conception. And so net zero, as I'm sure we're familiar with, is also kind of known as climate neutrality because it really is understood as this balance between the inputs and removals of greenhouse gases in order to stabilize human-induced climate change. Now, net zero was enshrined in the Paris Agreement back in 2015 and has since become a very ubiquitous kind of term in climate law more generally. And it's really interesting to see that its legal qualities are present in both hard and soft law sources and also amongst a range of actors, so no longer just states, but international organizations, non-state actors, companies. And so it has a really diverse appeal, which kind of typifies what could be considered a source of these new kind of norms. But the question is whether these can generate a kind of legal sense of legitimacy. And so to that end, it's kind of important to consider that net zero itself is not a norm, but it's rather a norm bundle. So that is something which contains fundamental norms, principles, standards and procedures, and is really a mix of these different types of norms, but presented in one easy bundle, as it were. And so to question whether it is a legal norm, one has to turn back to international law itself, because although the norm bundle comes from international relations, as a discipline, it's not actually that concerned about whether it's a specific law. So my next point is that net zero defies the canonical confines of the traditional norm analysis under international law. And we can see this because the power of net zero in terms of the range of actors it's attracting, the mix of hard and law sources, and the range of kind of shared understandings that are incorporated within it as a norm bundle really mean that it cannot be kind of compartmentalized into one of the four different aspects of four different sources of international law under the ICJ. And so these traditional conceptions of norms as well really require widespread and representative practice. And as I said, because it involves a range of practices of both hard and soft law and both non-state and state actors, really focusing on using the tools of traditional norm analysis excludes a lot of relevant practice and can give a very skewed view about how norm diffusion has really occurred. And interestingly, net zero environmental law, which is that there's a really strong relationship between environmental law and environmental science. And so the good news is that there's newer approaches, both specific to international environmental law, that reveal some further possibilities. And so we've got, for example, the notion of directing principles advanced by Desailly. We've got a notion of meta principles, or otherwise known as interstitial principles, advanced by Vaughan-Lowe. And we've also got these kind of principles of emerging international law, or potential principles, which were coined by Winifred Lang. And complementing these kind of international environmental law specific approaches to norm emergence, we've also had the benefit of some really more general thinking about what generates legal legitimacy for norms. And in these kind of ways, we've been able to broaden the scope of norm analysis to really focus on what what are the salient sources, and what kinds of practice can we expect legal norms to engender now, to kind of close that gap between the practice of law and our practice of thinking about it. So we've got these tools, but really I think at this stage it's important to reconcile some of the core synergies between the traditional approaches and these kind of newer ones that I've talked about briefly today. And this is important not least because there's been decades of really essential work that's gone into understanding norms and norm processes. And it's important because this work can really provide a firm foundational footing for how we conceptualize new norms going forward. Because at the core of it, all theories are essentially attempting the same job: to capture and classify norms in recognition of the really important role that they play. It's important for all parties, state or non-state, to know their legal obligations, know when they're creating new ones, and importantly, know the recourse that they have to solutions if there's contention over them. But it's also important to recognize the core differences. And I've already been through these kind of core differences, but what's really interesting when contrasting the specific approaches in international environmental law and the general approaches of international law is that environmental law theories really offer this rich possibility of interdisciplinary analysis. And for this reason, we can see strong complementarity with not only kind of environmental science disciplines, but also these theories from the constructivist school of international relations, which help flesh out what we kind of mean by new norms without the kind of confines of norm analysis from the ICJ. But on the other side of the coin, we've got international law theories, which have applicability to many different areas. Some, like international trade law, can generate a much more binding impact. So one key takeaway is that general international lawyers can learn from the diversity of norm practices in international environmental law. And at the same time, we've got international environmental lawyers that can actually learn and explore the synergies with other potentially binding areas of international law. And the latter one's crucial as well, because actually, as I'm sure we'll look at later in other presentations, there is some real issues with the current international law conceptions of how we structure norms. And reconciling these different approaches is one key way that we can start to address democratic deficit, whereby norms can be created and determined in quite a black hole of legal thinking. So this brings me to my final point, which is really an invitation to undertake this kind of reflexive learning process of norms in order to meet the rapidly changing legal world around us. And on this point, it's really interesting to link back to the topic of the conference, which asks actually what we can and must do for international environmental law. And as I hope to have kind of illustrated, thinking about new norms of international environmental law is one key way we can do this. And I hope I've convinced you today that thinking in this reflexive process about not only the norms of international environmental law, but the norm-making processes that underlie it is a worthwhile endeavour for us to work on. And so that brings me to the end of my presentation. Yeah, I really hope that this was a chance to kind of broaden some legal thinking, and I really look forward to your thoughts either by email or at the end of the presentations. So thank you.
So yeah, thank you to Inji for the presentation, and thank you very much to the organisers of the conference. It's lovely to see some very familiar names particularly from ANZL last year. My name is Eve Massingham. I'm an academic at the University of Queensland, and I'm presenting to you today from Turrbal and Jagera lands, which is the area that you may be familiar with as Brisbane, and I'd like to pay my respects to the traditional owners of these lands. I'm not an environmental lawyer. I've found the presentations this morning and then just recently Inji's presentation very interesting. I'm an international humanitarian or laws of war lawyer, but I'm undertaking a project at the moment which attempting to link the two. So I look forward to having a bit of a conversation with you about that. I will just share my screen so that you can see the PowerPoints. Hopefully that has come through clearly for everybody. So yes, as I've said, I'm a laws of war, international humanitarian law person. That's where my background has been. And I've been involved in the last few years in a project looking at this particular provision, which is known as Common Article 1 to the Geneva Conventions of 1949. I imagine that most of you are very familiar with the fact that there are 4 Geneva Conventions and 3 additional protocols that essentially regulate the laws of armed conflict. But perhaps less familiar with the fact that the first clause of most of these documents says that the high contracting parties undertake to respect and ensure respect for the present convention in all circumstances. Now it's the first provision of the laws of war, which every country has agreed to, and it's repeated throughout the laws of war. And yet it attracted incredibly little attention during the drafting phase. And there's been sort of different ways of looking at it over the years. I've got a few quotes on the screen there for you. An innocuous sort of opening phrase, this idea of it actually, really meaning something as a nucleus for a system of collective responsibility. And this idea that I certainly, in the work that I've been doing and with others, this idea of ripening fruit. And I think that's the camp that I would sit in for this particular provision. As some of you may know, there has been some renewed interest in this provision in recent years. The International Committee of the Red Cross engaged in a process of basically updating the commentaries to these conventions, starting with the first one of those that was released in 2016, which included obviously a series of information on Common Article 1. Now, essentially what the update project does in looking at state responses and practical measures and a range of actions that have happened over the last 70 years is come to this idea that, well, obviously the general principles of international law are about exercising your treaty obligations in good faith, and the general sort of notions that are known in other areas of international law, like, for example, the International Convention on Civil and Political Rights, to respect and ensure that the obligations are met, are clear. And there's a number of aspects of the Geneva Conventions where it basically tells you as a state what you're supposed to do anyway. So that's not particularly controversial. But what the ICRC's view is that there is also an obligation on third states. And this is a view that is supported more widely than the International Committee of the Red Cross, but they're the clearest articulators of it. And this is an obligation of third states to exercise their due diligence and, where they can, use their capacity and their influence to bring about respect for the laws of armed conflict. Now, in looking at this interesting provision, and this is a project that started many years ago with my PhD, where I was specifically looking at this from a weapons law perspective, it became really apparent that what would be a really interesting thing to do, and my co-editor, Annabelle McConaughey, and I engaged in this process, is to ask experts in a range of different areas that link to international humanitarian law to consider, well, look, let's leave aside a little bit the legal debates about this. There are strong views about whether it is a legal obligation or a moral obligation, or however you want to express it. But actually, practically, what are states doing that might give effect to this obligation of whatever nature you call it? And so this book that came out about 18 months ago is really a collection of different areas of international humanitarian law where people are saying, well, these are the practical things that are happening. And so you can see on the slide, there's we talk to people about, well, what does this mean in terms of detention operations? What does this mean in terms of humanitarian action? What does this mean in terms of counterterrorism approaches? What does this mean in terms of targeting? As you can imagine, with a project like this, there could have been another 30 chapters. And so what I've kind of been doing in the last couple of years is looking at some different areas where this might also be worth exploring. The most recent publication was looking at basically the entertainment industry and the depictions of warfare in our entertainment industry, and how states and private actors, of course, can work together to ensure respect for laws of war. I've also been doing some work on the role of religious actors. But one thing that's always interested me is this link with the environment, and how we can perhaps better use Common Article 1 to give effect to the obligation to ensure respect for the natural environment. Now, I've included in the slide here a few provisions of the Geneva Conventions, which, if you read a little bit beyond, the first line, you'll really realise, I guess, the rationale for including references to the environment in the Geneva Conventions. And it's got absolutely nothing to do with environmental protection in, I guess, sort of the saving the world for the environment's sake perspective. It's all about minimising humanitarian suffering, which is, of course, the main goal of the Geneva Convention, so a balance between military necessity and humanitarian action. And so the protections that exist in the laws of armed conflict for the environment are protections that are used for the purposes of the survival of the civilian population. So the military cannot ruin the environment because the civilian population need that environment to provide for themselves. And that's where the environmental protections come from in the laws of armed conflict. And so how do states therefore give effect to these particular legal obligations? Well, the International Committee of the Red Cross has started to give some thought to this particular question. And there's a couple of practical ways that they have proposed that states can live up to these particular obligations. So essentially basically engaging in a mapping process and making sure that areas of particular environmental vulnerability, for example, are mapped and designated and allocated. As you might be aware, although the Geneva Conventions apply in times of armed conflict, there are also a whole range of measures that exist in the conventions that need to be given effect before an armed conflict breaks out. You basically need to prepare your civilian society for the outbreak of armed conflict. And there are a range of things like having your medical services in order, having your civil defence services in order, separating your military and your civilian population. And so the environmental links here would be ensuring that prior to conflict, the places of particular vulnerability have been mapped out, and perhaps even the suggestion being made about establishing demilitarized zones for particularly fragile ecosystems and environments. The picture there depicting the military personnel giving a lecture is very much at the core of the Geneva Conventions, the idea of telling people about what the legal frameworks are. There are specific legal obligations in all of the Geneva Conventions to make sure that your armed forces, but also more broadly, people are aware of the rules of war and the protections that are included therein. Clearly, the idea of doing environmental impact assessments or various different risk assessments to identify these areas of particular vulnerability are really important. And also the ideas around exchanging best practice to try and improve compliance with these provisions that protect the natural environment. I've also included a stock image of a person in a field with a military looking weapon as a sort of reminder of the obligations of non-state actors here. Clearly, the Geneva Conventions are directed towards states, and the obligations are very clearly on states. And of course, as you would be aware, also on individuals through international criminal law, not to violate the laws of war. But there are specific obligations on non-state actors. These include the fact that there are groups such as Geneva Call who have worked with non-state actors to get them to engage with and sign up to particular principles of international humanitarian law. There are also, there's a really great example from the African Union. So the African Union's Kampala Convention on the Protection of People from Internal Displacement includes specific obligations for non-state actors, as well as, so for armed non-state actors, as well as for other non-state actors in their legal framework. So that's just a fairly recent 2009 document example of the inclusion of these actors. So these are some of the practical ways as kind of a starting point for the work that I'm doing to think a little bit further about. And then I've got some, I guess, some considerations for further thought that I think the project will go towards. So there is, of course, this environment as this question, sorry, as to whether the environment should be protected itself in its own right or as a civilian object in situations of armed conflict. I'm quite on the record in a number of contexts of saying I think it's very unlikely that we're going to get additional Geneva Convention protocols. I'm not advocating for that necessarily or for a specific law on this, but it is clear that these conventions are living documents. The laws of international humanitarian law very much work on a principles approach, not a entirely prescriptive approach, and so they're absolutely dynamic in that sense. But of course, there is a lot of acknowledgement between the links between the environment and human health and well-being, but whether those two things should be entirely linked or whether there should be sort of a separate line of thought is something for further thought. There is, of course, also the interplay between the various different legal frameworks, and Inji's presentation was really interesting for me to think about in terms of some of those things around international lawmaking and the discussions in international environmental law around ecocide and other environmental law crimes, obviously the discussions in relation to trade law, the interaction of all of this with international humanitarian law and existing international criminal law are also of interest, as well as the interaction with domestic legislation and implementation, because I think it's really, really clear that a lot of international law successes come through solid domestic legislation and implementation. And I've spent quite a lot of my career primarily with the International Committee of the Red Cross and the Australian Red Cross, basically advocating and supporting states in relation to this domestic legislation and implementation of that legislation. So I think that's an interesting area for further thought, particularly around protection of the environment. I think the question of the fact that clearly all of this is compounded by climate change, and there are a number of reports out in recent years by the UN and the ICRC and other entities about sort of the exacerbation of situations of armed conflict and climate change acceleration. Does this change any of the obligations? Does this change the way that we should be thinking about protection for purely civilian objects? And is it for purely civilian benefits? And then I think the other thing to think about, although I do believe that today's warfighters are quite sensitized to these obligations, is the challenges in actually foreseeing the long-term environmental destruction of particular actions. And my current role at the University of Queensland involves thinking quite a lot about future technologies in warfare, and particularly autonomous systems. And so I think there's some interesting questions that arise around the ability of commanders to foresee the impacts of the actions that they're taking. The other point that I want to make is that obviously alleviating the effects of armed conflicts involves a whole range of actors. And so, we talked about earlier the fact, well, Geneva Conventions are addressed to states, the high contracting parties who have the legal obligations, but it's clear that they can't achieve them without a whole range of actors in society. And these are just a few of the ones that are particularly relevant to the laws of armed conflict. But all of these different actors need to play a role. I think I have about 3 seconds left in my 15 minutes. So I'm just going to go on to my final slide, which is really, I guess, to link it back to the book and to link the conclusions from the book back to the application to the natural environment, and essentially how to prevent the damage and destruction that we see on the slide. This is an image from Syria. Obviously, individual states' actions are important to encourage respect for IHL, as well as building respect through legal and normative frameworks. And in doing so, there's a clear role for a range of actors. There will be situations where direct action to enforce respect is needed, but there'll also be more broadly a sort of what we concluded in the book was essentially a toolbox of measures rather than a checklist, whereby states are exercising their due diligence to ensure protection for the laws of armed conflict, and in this case, for the natural environment as well. So this is very much the beginning of a project on sort of taking these ideas and thinking about it from protecting the natural environment in times of armed conflict perspective. And I'd very much like to chat to anyone who has any thoughts on it following the presentation. Thank you very much.
Thank you, Eve. That was very interesting perspective for us to be able to have here. And I've got to say sorry briefly, both to you and to the previous presenter, Inji. I've had some internet issues over here. I didn't want to be the person with technical issues, but here we are. And I'm sorry that you missed out on the introduction, but I'll just say that we're very lucky to have Dr. Eve Massingham here, and her perspective from a humanitarian law approach is very interesting contribution to this panel. And Inji, thank you for your presentation as well. I was enjoying it very much until I dropped out. Okay, so we will now move on to our third presenter, Dr. Nengyu Liu. Nengyu is actually the director of the Center for Environmental Law here at Macquarie and an associate professor at Macquarie Uni. He was educated at the School of Law in Wuhan University, China, and got his PhD at Ghent University, Belgium. He's taught in University of Adelaide in New England, and was a European Marie Curie Fellow at the University of Dundee, Future Ocean Postdoctoral Fellow at the University of Kiel, Germany, and has held numerous visiting research positions around the world. So I'll hand over to Nengyu now, and he can take us away with his presentation on China and international environmental law, balancing rights and obligations.
Yeah, thank you, Ethan. Can you hear me well? Yeah, good. So hello, everyone. First, I would like to acknowledge that we are sitting in the traditional owner of the Daru people of the Macquarie University land, and I would like to sincerely pay my respect to the elders past, present, and future. And also welcome from my side for everyone to attend this year's Frontiers conference. And it is really a great pleasure, and thanks to the hard work of my colleagues here in the center, Paul Goving, Michelle, Lim, Sarah Vanderfield, Nis Jala, McDonald, and Ethan in particular to make this happen following our successful global dialogue on biodiversity law and governance conference last year. My presentation today is about China and international environmental law. So this is a work in progress that I have been working this summer, a book project to be published by Cambridge University Press on the Cambridge Handbook of China and international law. So we are now living in a increasingly dangerous world. We have had, I'm talking about human beings as a whole, that we have had thousands, more than 3,000 multilateral environmental agreements till today, especially after the 1972 Stockholm Conference on Human and Environment. But it is apparent that more than 3,000 multilateral environmental agreements, or we call it in general international environmental law, has not successfully dealt with the profound and very deep, profound and very imminent the global environmental crisis. And on the other hand, or at the same time, the international community and international law in general are now driving by several major forces. This geopolitical tension that is rising every day, the new technology that we have been enjoying, but also bringing a lot of challenge, and also this imminent, if not existential, environmental crisis, especially the global warming and massive biodiversity loss. So my presentation today will pretty much focus on, when we talk about China and international environmental law, I will pretty much focus on the first driving force of the future development of international environmental law, that is the geopolitical shift and tension. There is this very popular term, rules-based international order, that has become widely used, if not become a dominant narrative in the Western or English media, at least, about that this is a worldview or a kind of a word of a kind of system that is now being challenged by China and Russia. So there is this rules-based international order, according to Chatham House, defined in 2015, is a framework of liberal political and economic rules embodied in a network of international organizations and regulations, and shaped and enforced by the most powerful nations, being the United States. So it popped up and frequently used by the national defense strategy of Australia, UK, and United States, and now is also frequently mentioned by these countries' foreign policy, and also to a certain extent in the European Union, we see the EU leaders using this term as well. So this term is very interesting. I found this term really interesting as a legal scholar, especially when it comes to the environmental sphere. So I was chatting with really just by accident, a Kenyan colleague in 2016 when this term first popped up. And his instinct kind of reaction was, oh my God, it's very colonial. I didn't realize that, but I guess he told me, like, for people who have had experienced the colonial kind of time, when you talk about the rules-based international order, you immediately think of those old days. This term is very interesting in many ways. First, I find that it's really a term that can be manipulated. So it's really, it looks like that we are talking about rules, but actually it's really very much depending on who is talking about the term. So there is a hidden power structure behind this term. And then when we are talking about rules, we're not just talking about rules, but also about order. Because as an international lawyer, when we see rules, we may just immediately think about, yes, rules means international law or public international law or whatever it is. But then the question is it true? Because now from a Chinese perspective, not Chinese perspective, from the Chinese government's perspective, it is very much attacking this term and also trying, I would further explain that their position is like they are trying to use a very different kind of worldview, saying that China is upholding the UN-centered international legal system. So, I mean, if the rules-based international order, when we talk about rules, is just about international law, then they are talking about the same thing. But then why are they clashing? So my analysis is actually here the rules is very selective. So it is a selective bunch of norms that is determined by the order, that the dominant order or the US anchored system, which really suits the dominant power's interest. So then it comes to have some problems. For example, what about the rules are contested? Like when we see the application of precautionary principle, or like what about the rules are under development? So I mean, when you are defining that someone is challenging the rules-based international order, that you are assuming that the rules are set. But as we will further see in many areas of international environmental law, in particular in the final frontiers, the rules are being developed. So the inherent tension that I see between the rules-based international order on the one hand and international environmental law on the other hand is this fundamental question that I'm asking, and without answer is international environmental law part of the rules-based international order? Because if it is, if the answer is yes, of course, it's a set of liberal institutions and legislations established after the Second World War, anchored by the major power, then there are two problems. If the answer is yes, first, what kind of power are we talking about? If we are talking about the power of examples, like President Biden said in his inaugural kind of a speech, then my doubt is, what about the U.S. practice in the field of the international environmental sphere? And also more importantly is the U.S.-China rivalry is now defined as competition, but also there is also hope that there can be cooperation in areas of shared interest, especially when it comes to climate change and environmental crisis. But the problem is, if the rules-based international order is a very dominant kind of narrative that we see in our English-speaking world, then how can you be sincerely and effectively cooperating with a challenger when you already define someone as a challenger, and how to collaborate effectively, and especially when it comes to dealing with the global environmental crisis, that the cooperation is very much needed. All right, so now let's turn to China. China has, as I just mentioned, China has kind of like has been presenting a different view, saying that they are trying to uphold the UN-centered international legal system. But the real question here is, what kind of rules or what kind of international law does China want, or does China want to achieve? So if you are talking to the Chinese, several Chinese scholars from mainland China, I read the papers about China and international environmental law, you will see that, oh yeah, there are 3 stages of China's engagement with international environmental law: the follower, the participant, and now taking the leadership to a certain extent. In my view, that's actually very much kind of falls into the first narrative, the rules-based international order. Because yes, now you are taking the leadership, but there is a leader there in that rules-based international order. So what does that mean? That means you are indeed a challenger. So I mean, that's kind of from the view from inside China. My findings about China and international environmental law, and what kind of international environmental law does China want, is very much based on the following kind of case studies that I've been doing. So we, especially in those final frontiers, so Arctic, Antarctica, deep sea bed, and also to some extent the high seas, because in these areas we see that the rules, the international environmental law are being negotiated and also kind of developing quickly and intensively in those final frontiers, where human beings now can have better access with better technology and trying to protect, but also explore and exploit the natural resources there. So the narrative from the Chinese government, I think now is becoming more and more more and more clear. That is a balance between conservation and sustainable use. And you will see in different frontiers, the narrative changed slightly. So when it comes to the BBNJ, the high sea negotiation, it is very clearly declared that China wants a balance between conservation and sustainable use in the high seas. And when it comes to Antarctica, it's especially this kind of marine protected area initiative, the establishment of marine protected areas in the Southern Ocean, which is under negotiation in Kamala, the Commission for Conservation of Antarctic Marine Living Resources. You see that China insists a balance between the rational conservation and the rational use. And in the Arctic, on the one hand, China is now pushing the Polar Silk Road. The Polar Silk Road is pretty much a significant economic initiative. The Yamal liquefied natural gas project in the Russian Arctic. But at the same time, the sustainable use of the environmental protection is also a component. So in the newly in the 2008 Central Arctic Ocean Fisheries Agreement, which entered into force last year, we see it clearly that the China's narrative is like, yeah, environmental protection and sustainable use. So in the deep seabed mining area, China is also very active in seeking the application and approval from International Seabed Authority of those areas for future exploitation. And the narrative is slightly different. It's use first and then environmental protection second, but it's still a balance. So when you're talking about balance, it's actually a very subjective term. That what do you mean by balance? So anyway, so that's what we have been seeing. So this is the post 2020 framework that is now being negotiated in the COP15 of the UN Biodiversity Convention, which is going to be held in Kunming this April. So it's also the same narrative. So I will just stop here. What my conclusion is, one from I think for China and the international environmental law, or for a better development of international environmental law to address our profound global environmental crisis, there are blind spots from both, let's say, the West and China. From the West, the blind spot is this inherent tension between the rules-based international order on the one hand and international environmental law on the other hand. And we have seen that. I noticed that because when I was observing the Kamala annual meeting last year, it was a jaw-dropping experience that how tense it became in the environmental sphere between it's still rules-based because they were engaged in discussion, but oh my God, the discussion was so tense, which in the past you would see that in the UN Human Rights Council and to a certain extent in WTO, but now it is spreading. So this rules-based international order is not doing its job to facilitating the cooperation in the international environmental law sphere. Well, there are also kind of blind spots from the Chinese side. First, when China is talking about the balance between use and environmental protection, then where is the boundary? And the order is a shifting boundary. And the second blind spot from Chinese side is, which I think this is subconsciously being ignored, is it's not just a balance between use and the environment, but it's actually to balance with someone. So this is a confronting position on at some point. It's like, but it's subconsciously unaware by the Chinese kind of negotiator. It's like, it's actually not just about balance between use and environment. It's just because it's also about balance with who. And finally, this is something I would hope that US and China could both internalize, and which is the theme of our conference today, is where is the responsibility? So when China is talking about the balance between use and environmental protection, it is pretty much like it's really just about rights and obligations. But obligations are not responsibility. Responsibility is more proactive. So that's something I think I see there is an opportunity that China can do differently in the development of international environmental law when it comes to, in my case studies, in those final frontiers. But this is a blind spot. And to internalize the responsibility will help China to go beyond itself in the development of international environmental law in those final frontiers. And here, I think I just stop here and I look forward to any question. Thanks.
Thank you, Naya. Yeah, that was a very interesting take on the power dynamics that we see when it comes to international lawmaking, and also how that relates to the environment specifically. So thank you for that. Okay, we'll move on to our last presenter. We've got Aditya Bharata, who is a researcher at the Maharashtra National University in Mumbai, India. He focuses on international law, third world approaches to international law and critical legal theory, and has presented papers in conferences and workshops hosted by University of Cambridge, King's College London, University of Pretoria, Graduate Institute Geneva, among others, I guess, including today. And Aditya's presentation is titled Third World Approaches to International Law and the Duty to Cooperate in International Environmental Law, Stories of Resistance, Discretion, and Social Justice.
Thank you. I'm audible? I'm audible too. Yeah. Thank you for this very generous introduction. And before I start, I take a moment to express my gratitude to the organizers for offering me this platform to speak on such a relevant topic. And the theme of this session is itself very relevant and timely, because it's really fascinating to see the transformation of global law and how we are responding to the challenges of Anthropocene. So I focus more on TWAIL, that is known as Third World Approaches to International Law. And as Ethan already said, I'll be talking about duty of states to cooperate. Herein I'll be talking about stories of resistance and decolonization and all these things. So I'm in the process of converting this abstract into a paper and rely more on my paper. So as we all know, TWAIL is a scholarly movement that seeks to assess and to advance and promote international law to transform itself into a system that is not based on power, but on justice. And the reliance of this ideology is considering how the global South norms impair or advance the interest of the states in the global South. So I focus morely on deconstruction of international environment law. And in this context, I'm using what we discuss when states are responding to crisis and how states are have a certain inherent duty when we talk about international law. So in my abstract, I argue that there are growing host of challenges, predominantly transnational, which are undermining the legality and practicality of the international duty or obligation of states to cooperate in international environment law. But this duty to cooperate or obligation of states, with the rise of alternative critical approaches to international law, subaltern communities are questioning the epistemology and are actually questioning the validity of the term global when it comes to implementation of duty to protect the global environment. So I am predominantly arguing that third world approaches to environmentalism in the global South are actively developing variations of duties under the substructures of the present international environmental law framework, where obligations are being emphasized more on differences in responsibilities and differences in duties. So in its structural sense, international community is duty bound, and it is duty bound to encourage and assist states to fulfill their international obligations. However, the intuiting factor determining the discourse of state action are the geopolitical or the socio-political interest. These challenges are a result of resistance by transnationally organized subaltern communities that seek to counter the norms of international environmental law, predominantly which are supported by the developed world. And this response or this resistance is based through powerful articulation of something known as social justice. And this is also a journey of placing the norms of social justice and how global environmental law governance actually functions. Unlike the existing norms of duty to cooperate in international environmental law, which is a result of consensus built by the global north, the new norms of cooperation and obligations are articulated by third world states are asserted on the values of global welfareism and social justice. So I'm also analyzing in my draft paper, I'm also trying to analyze the scope of developing a third world perspective on how these principles can also become a part of interpretation of international environmental law when we talk about general principles of international law. So I'm also exploring this aspect of TWAIL movement that was actually very skeptical and was kept disengaged from the formulation of international environmental law, and how this movement has now penetrated into the politics and methodologies adopted by states to cooperate in international environmental law. So to just quickly introduce this idea, this duty to cooperate or duty of obligation of states to cooperate has been very central to the protection of global environment. When we talk about Stockholm, we talk about Principle 24 or Principle 7 and 27 of Rio Declaration that talks about cooperation or this idea of cooperation. But when we talk about cooperation in its simplest sense, it is working together to pursue a common goal or a common task. But what I argue here is that, is there a common goal when you talk about environmental problems, such as a duty to cooperate indicates the presence and circumstances that require states to work together in order to pursue an identified end. But what are we really witnessing an era where states are working together? In the most general formulation, the rule concerning cooperation identifies the end sought and requirement to cooperate. For example, Principle 24 of Stockholm Declaration is not formulated in a way that talks about proper cooperation, because Principle 24 reads, international matters concerning the protection and improvement of environment should be handled in a cooperative manner. So there is Neil Craig, a scholar who argues that this principles goes on to note that an essential form of cooperation is through multilateral arrangements, and they emphasize more on interest of states. So formulated in this manner, states cannot be compelled to achieve a particular goal, but rather they must account for the rights and interests of other states in their activities. So when we talk about this idea of discretion, like as Ronald Dawkins talked about discretion, that discretion might be viewed as a lawless zone. Okay, and even Koskinemi sees in this structure he sees that the inevitable political nature of international environmental law. So here we talk about what exactly is the element of mainstream. So the term mainstream in international law scholarship signifies a dominant way of framing issues and the consequent development of the legal regime. This mainstream approach towards duty to cooperation or international environmental law treats this system of objective principles as neutral rules that emanate from states' will, either directly through treaties or through customs or whatever the source may be. The main feature of mainstream can therefore be identified as neutrality, universality, and its impersonal nature. The universal nature signifies the application of same rules to everyone. It also signifies the framing of issues as universal as opposed to a decentralized or diversified framing of issues. For instance, environmental issues are generally framed as universal in nature. Everybody is counted as a victim of environmental crisis, and solutions to environmental problems are understood as to come from everyone. In other words, international environmental law problems and solutions are framed as everybody's concern. For instance, global environmental crises like climate change or biodiversity loss or species extinction are often projected as crisis of humanity as a whole, and thus underline a need for everybody to act. So this construction of a legal regime is based on neutrality, universality, and autonomy. So it is not to say that the whole international legal architecture relating to the environment is devoid of any consideration of the diverse nature of environmental issues. In fact, we can talk about legal regimes such as climate change law, or often cited of having laying down differential legal obligations for different state practices. However, this does not change the fundamental character of international environmental law, which are neutrality and universality. Any attempts to incorporate diversity is either an exception or a fast diminishing towards eagerness to achieve universality. What unifies the duty to cooperate across these forms is in its structures. States' discretion requiring that state exercise their discretion in a way that are responsive to community interest. In the context of normative development, state retains their discretion to determine for themselves the extent of cooperative activities undertaken. And this duty to cooperate is rarely structured as a duty to agree or even negotiate. Okay, so this idea of mainstream narrative is so dominant that it has become the default lens through which international environmental law is viewed, understood, and even discussed. The power of narrative is such that the mainstream is often regarded as the only stream. Here comes the role of third world approaches. Principles and doctrines have become the only disciplinary tools that are discussed. One of the ways to avoid this epistemological crisis is to revitalize theories, to rethink the critical approaches. This neutral framing of environmental crisis is to be replaced with critical framing of laws, by deconstructing the universalist and neutral framing of environmental issues. One such approach could be, as my earlier presenter talked about, studying the historical and critical angle. Okay, so studying history is an effective tool to deconstruct this universalist framing of international issues and rethinking what a rule-based society would look like. A historically informed approach helps us to also develop better understanding of critical approaches. Here comes the role of decoloniality, studying of how colonialism and its impact on the history of exploitation of people and environment. Here comes the importance of developing alternative identities and alternative ideologies. So as the theme itself talks about the response of law to new challenges of Anthropocene, what we need to understand is that law essentially is anthropocentric in nature. It looks at everything, including the nature from a human perspective. But we can also see that the history of human beings is also full of exclusions on the basis of race, gender, caste, sexuality, among other things, and the consequent domination of few over the excluded others. While many of such exclusions have met with resistance from the excluded people and eventually led to recognition of them as part of humans, the centricism of humans strongly continues which marginalizes the environment as well. So an understanding of IEL from a global south perspective can have multiple manifestations, which I argue. The first is that environmental law is often depicted as a product of global north's environmentalism, and global south is seen as either a follower of the global north or a set of nations or people to be protected and saved from the planet in this system. Such a view or understanding emerges either from the ignorance of history of the global south or from the systemic epistemologic myopia in which we live. So it's very important that in this discourse, we also take into account Justice Veeramanthri's separate opinion in the Gapchikovo case, wherein he talks about how alternative identities have to find a place when we talk about responses of state. The second argument that I put forward is that looking at North-South relationship as a power relationship. Domination is more likely to be an inherent feature of the way environmental law functions in the present system. For example, we can see that the North is focusing on issues like ozone depletion or species extinction, while the South is struggling with issues related to access to energy and even food security. So there is a difference in the issues. And when we talk about universality, we need to think, can a universal solution be a response in how states will respond to the crisis? Should there be universality in how states should cooperate? The third argument that I put forward is that while domination of the global north over the third world people and countries is one focus point to develop a critical approach to international environmental law, it is not sufficient to explain the nature of law completely. In fact, international environmental law is also a product of North and South conflict. So third world countries have been projecting immense resistance to the domination of global North, which has led to emergence of certain rules and principles as advocated by third world countries. So we need to find also factors relating to economics, factors relating to historical linkages. For example, the idea of common but differentiated responsibilities, or developing ideas in alliance with permanent sovereignty over natural resources, common heritage to mankind. So these could be good illustrations on how the demands and aspirations of third world countries can find an appropriate place in a decolonized system. So I actually in my paper talk about rereading and reanalyzing something that we discussed today known as duty to cooperate. There is a need to rethink how discretion would be exercised. There is also a need to actually structuralize and formulate a principles and law-bound manner in which duty to cooperate should be read. Because as the famous proverb goes, until the lions have their own historians, the tales of hunt will always glorify the hunter. So with this, I open the floor for questions, and I'll be happy to address some of the issues. Thank you so much.
Thank you for that presentation. That was a very interesting perspective. I think I might actually have to hand over to Paul if Paul's there to take the question and answer portion of this presentation, because I'm having internet issues ongoing. If that's all right, Paul, I'm sorry, but I don't want to drop out in the middle of asking a question. So.
Yep, I'm here. Ethan.
Okay, thank you. Thanks.
Okay, sorry about that. Thanks, Ethan. I know it's difficult to try and persist when technology gets the better of us. Yeah, I'm sure that will be weaved into some of these discussions regarding responsibility as well. Okay, so yeah, I'm just going to open up the question box, and I will, as in the previous session, allocate questions accordingly. Having a quick look at the questions, I think they're quite particular to certain speakers, but I also think that by all means, all of our panelists, if they feel they have something to contribute, please do so. So the first question is from Felix, and it's for Eve, Dr. Eve Massingham. The question is, could you please explain how the African Union protects the environment, and what is your opinion of the success and failures of the convention you alluded to, which I assume means the Geneva Convention? Yeah, Eve, I'll pass over to you.
Thank you very much, Felix, for the question. So when I was talking about the African Union, I was specifically talking about the African Union's Kampala Convention on the protection of internally displaced people. The broader question of the African Union protecting the environment, I certainly wouldn't purport to be an expert enough on protection of the environment by the African Union, but I did spend some years working in East Africa in particular, and there are in fact actually quite a lot of sort of projects, particularly land protection projects from regional organisations sort of as part of the African Union framework. But my point in bringing up the Kampala Convention on internally displaced people was specifically about the fact that it gives particular obligations to armed non-state actors in quite a unique way going forward. But more broadly, it's a really interesting convention, and if you're not familiar with it, to have a bit of a look at it from the environmental perspective, because it provides specific protections for populations. Again, it's a bit like the international humanitarian law framework in that it's thinking about the survival of the civilian population. But there's an entire clause, I think from memory, it's Article 10, which is about project-induced displacement. And basically the convention is seeking to protect populations from exploration and exploitation of natural resources, and it takes measures to promote sustainable livelihoods. So yeah, it's certainly not a perfect solution, but it is a convention that is making some difference. And in that regard, I would just flag some reports of the International Committee of the Red Cross. They did a report in sort of 10 years on from the Kampala Convention, and then another one that I was involved in that came out in 2019, sort of looking at the successes and the ongoing challenges, which absolutely still exist, but of the Kampala Convention on internally displaced people. So yeah, that might be a source of some protections of the environment from the African Union framework.
Paul, you're muted.
Oh yeah, sorry about that. Thanks, Eve. Sorry, I meant the Kampala Convention. Thank you for your very generous response. Given that was quite a specific question, I think for Eve, we'll move to the next one, and then I'll sort of ask if anyone can sort of contribute here. The question though is directed to Inji. So it's from Sri from Indonesia, Universitas Islam. Now, the question is about Inji's development of the 10 points that she worked through on the slide. So the question is, what are the legal challenges when the international community hopes to create a new legal norm, or legal norms indeed, based on the 10 considerations that Inji shared. Yeah, so from Shree's question, I think the application here would be towards human activities which cause pollution and environmental degradation. Inji, I'll pass over to you. Thank you.
Thanks, Paul. And yeah, thank you for this question. I think, yeah, I mean, it's a really great question to really consider how these like new ways of thinking about the norms can actually translate to kind of to fixing some of the issues. And I think, yeah, at the start, it's just important to establish that there are numerous challenges, and all the speakers have kind of talked through the different ways in which it is challenging to establish a legal norm and the reasons why. And I think, there's three key ones that came across in my points, which is that, fundamentally, in a lot of ways, there's this disconnect between the practice of law on the ground and what, international actors do on a daily basis, and the way that theorists think about the law and the kind of structural processes that are in place to resolve legal questions in that regard as well. And the second point is that there's fundamentally a lack of consensus about not only the norms of lawmaking, but also what the substantive norms kind of are and to what extent they have this legal potential. And so for on the point about pollution, environmental degradation, there'd be a range of views about whether and to what extent different principles may apply to it, and how legally binding, for example, those should be. And thirdly, and as well as that has been touched on in other presentations, is that looking at the current structures of the traditional conceptions of international law are very hegemonic, and so there's that real democratic deficit between the actors that have instantiated the practice of norm emergence in the past, and how we can kind of address those challenges going forward in a space that wants to shed light on that new norm process, because that is where a lot of legal making has been in a black hole, as has been addressed. And I think in looking to your the later points, one of the major criticisms of the traditional approaches, and one that I didn't mention in my presentation, just because I feel like often it gets used and it's not in and of itself a good enough reason, but the traditional conceptions have been called glacially slow processes, and so often we'd see norms that developed over decades, and the issue regarding the application of this to environmental law is, as we know, environmental law issues arise all the time and can develop really quickly. And so, to use your examples of environmental degradation, that can occur on scales of years and months. And so, we find that the scales of legal norm development really don't match up to, the issue development on the ground, which again links back to that disconnect between law and practice. And your final point about whether these 10 considerations might solve this problem, the short answer is no. It's just a starting point about thinking about how to approach this framework. But it does link to my broader PhD research, which is setting up this new norm framework of unpacking the processes that could form part of, how a legal scholar or a practitioner could actually approach considering what new norms are and what the substantive legal meanings and potential legal practices of those new norms are. So thank you for your question, and yeah, look forward to the discussion.
Thanks, Inji. Great. I mean, that's a great question as well. I've always been fascinated as to how the process works, and you've mentioned the glacial pace of it and all, etc. And I think that's something which, unfortunately, for environmental law, is something that needs to be sped up. Did anyone else like to contribute anything to that particular question? No? Okay, I'll move on with the next question in the list. This one's directed to Ninye Lu. Again, from Shree, who asks in this question, based on the presentation, he should like to know further the lawmaking process in China concerning international environmental law. As Ninye mentioned, China is committed to a balance between rights and obligations in international environmental law. And the question is then, how to address the asymmetry, the justice asymmetry, that is, between the global north and global south related to utilizing shared resources, such as fisheries in the high seas and protections of forests to reduce greenhouse gas emissions. The second question or follow-up question, what kind of international principles, or what kind of principles of international law have to be adopted by the Chinese government in the lawmaking process? So Ninye, could you guide us through your response, please?
Thank you. Thank you, Sri. This is a very broad question, and it's a fantastic question, but I'm not sure whether I can fully answer the question here. But my instinct kind of response is, first, inequity is a reality. I mean, we should never deny that there is a huge gap in equity between the developed world and the developing world when it comes to almost everything. Everything. You think about everything, everywhere. Antarctica, Arctic, outer space, deep sea bed. That's the frontiers where human beings can go, and you just see these huge gaps between the rich and the poor. And I think we should never forget about that, and we should address that as much as we can. But when it comes to China, it is a very unique kind of status that China has been presenting to the future of the international environmental law, which I would call China as a hybrid state. So it is not really a fully developed dominant Western state, but it is also, it still has large numbers of population that is under poverty, but it's not a developing country without technology and also without human resources to access and to utilize the natural resources in this planet. So, I mean, what we have seen these days is a blame game, which is wrong, between China and the West. It's like, oh yeah, China has done this and that. Yeah, they should really pay more attention to X, Y, and Z. And China would just argue back saying, hi, see, that historically, we haven't done that much. It's all about you. So you have historical kind of responsibilities. So you see, this is a blame game, which I think should definitely be abandoned between the both sides. What I can't speak on behalf of China that which kind of principles they should dominate, which they should adopt in the future of the future development of international environmental law. But I think these two kind of issue, the inequity and also the blame game, this needs to be there. And also the final thing is, what I'm trying to say is, like, let's come back to the theme of our conference. That's why I'm calling for in this paper, China to internalize the responsibility kind of discussions and also debates into the future law making from the Chinese side. Because the thing is, for so long, because China is such a unique status, it is really catching up and trying to kind of learn and also challenge in many ways the dominant Western countries. Then the focus of the Chinese decision making, as far as I can observe, is always like they are trying to see. That's what I presented in my paper. Is like they are trying to balance, not just balance rights and obligations, but really to balance the dominant power as a rising power. But this is not enough. This is not enough. If we accept that such huge inequity is there between the rich and poor, and China at a certain stage, and I think the time is here now. It's really, it's not just in the future. I think it's time now for China to think more and also to do more to incorporate the responsibility into the future decision making when it comes to environment, but not just the environment space. I think it's more when it comes to trade or human rights. It's all the same. But here I'm only focusing on the international environmental law. So that's kind of my very kind of brief thoughts on that question. Thanks.
Thanks, Ninye. Next couple of questions here, one from Shri and one from Michelle Lim of the Centre for Environmental Law, are both directed really for Aditya. So I'll just quickly run through them. They both relate to his, I think, excellent presentation and the insight into this idea of the division between global north and global south in international environmental law, and this, I think, topic of resistance. So the first question from Shri basically asks about the domination of the global north, of the global south in the international law context, and how these different interests might be reconciled in the context of IEL, particularly in the context of colonization and well, the legacy of colonization, as I think Twale, tends to put it. The second question, quickly, I'll just ask this now from Michelle, and she's made a note as well, Ninye, if you'd like to contribute to this as well, is the question of whether international law is international. And what you think about this, how we might make international law international. So Adi, I'll pass over to you, and if we have time, Ninye, your thoughts are obviously very, very much valued.
Thank you, Paul. So coming from India, I can truly, vouch on this idea that the horrors of colonialism still haunts how India as a colony approaches the environment. Okay, we are still witnessing this horror continues, and the way we respond after 70 years of independence, we are still, mixed up with this idea. But there's when this question comes up even in international discourses, why did you miss the bus? This is a question that people ask. Why did the global south miss the bus? But the idea that one of my favorite writer points out that we missed the bus because we were thrown under the bus of this lawmaking. So when I talk about when this idea of how global south respond to this crisis, what we need to also take into account is that I am not a pessimist in a way. I am talking about we were out, we did not have a place, but there have been some good illustrations on how the aspirations managed to find a place in international environmental lawmaking. For example, we can talk about the permanent sovereignty of natural resources. It reflects the aspirations of third world countries to take complete control over the natural resources, as opposed to the colonial scenario of how the use of natural resources in the colonies primarily benefited the people of the West. For example, the history of common heritage of mankind also tells a story of third world initiatives and assertions at the international level to prevent global north from monopolizing the environment. So I think the primary task is to actually deconstruct this whole discipline. Okay, it is unimaginable to discuss and comprehend these important principles of international environmental law without providing an historical context and historical account for other players. And this other players I talk about is the global south, who were largely kept out in the mainstream discourse of how this law has been framed. So I feel there is a need to relook, there is a need to rethink, and this is a continuous process. And it will not happen unless there is stakeholdership, unless the global south, the countries of global south who were earlier not part of decision making, find a proper place. And when I talk about representation, I also talk about the capacity to represent. It should not be a mere representation that your views are taken into account, but it does not find a place in how the final product comes out. So representation should be actual, it should be optimal. So coming to the second question of how do we make international law really international? So this is $1 million question, and in this context, I can say that international law can truly, in the context of international environmental law, we can actually come to a consensus of universality if we acknowledge the diversity of this system. Okay, states should be bifurcated in terms of their global environmental degradation, their exposure to vulnerability, their capacity to tackle problems, their economic capacity, the political differences, and all these things should find a place in the making of law. Okay, that is the only way in which I feel that is one of the ways in which we can actually try to make the system of law more inclusive rather than the exclusionary nature of the system. Now, I am saving some time for the professor to intervene.
Thanks. We're quite short on time, but if everyone can maybe hold on for another 5 or so minutes, I think it's worthwhile. I think we've still got some excellent questions and discussion to come. Sorry, there is a lawnmower outside my window. I can't do much about it just now. Ninye, did you want to give a response to those questions?
Just very briefly. I think, is international law international? No, of course not. That's very clear. But I think there are many kind of aspects towards the solution. And one particular point I made in my presentation today is this term, rules-based international order. I mean, this rules-based international order is not an international legal term, but it is inherently narrow-minded. So, I mean, how to make that, if that is an international order? I mean, let's just accept. I think I would accept the fact that the rules-based international order is the existing international order. But then if that is the fact, how could it be made more inclusive? So that's just the question that I'm raising, rather than providing any solution to that into the international law, international debate. Yeah.
Thanks, Ninye. I know we're just over, but there's just a couple of questions I think that might be worth some brief responses. Now, I noticed, Eve, I think you were typing an answer there to Ganasan's question, but I'll read it out anyway, in case anyone else has anything to add. The question is based on based on fisheries, and Ganasan says that in their career as a ex-fisheries prosecutor, PRC vessels not only involved in illegal fishing, but also large-scale turtle poaching in other coastal states' waters in South China Sea. And the question there is PRC, is the People's Republic of China practicing lawsfare? So that's an interesting one. The second question is, I think, quite directed at Ninye, and it's about the China's Belt and Road Initiative, especially the proposal on green finance. Could this play a positive role in China's future engagement with international environmental law, and if so, in what form? That's from Alison Zhu. Thanks, Alison, for that question as well. So I suppose, Ninye, I think you've probably got something to say on both those questions, if you don't mind giving us a brief response.
Yeah, very briefly. I think for the South China Sea, the issue is very complex, especially when it comes to the territorial claims from its coastal states, including China. And of course, China's territorial claim is pretty much within its so-called 9-dash line. So it's very kind of large area. So I think that is the fundamental kind of legal basis when we are talking about fisheries issues in the South China Sea, because there is a dispute. Well, there is supposed to be a dispute about territorial claims in the South China Sea. When it comes to the Galapagos MPA, I think to be very accurate, there was a kind of an incident dates back to, I think, 3-4 years ago, when a transshipment kind of fishing vessel was caught in the Galapagos MPA. But remember, Galapagos MPA is within Ecuador's exclusive economic zone, and all those kind of distant water fishing vessels, they are doing their kind of work outside any particular country's jurisdiction. But here, the problem, of course, is, yes, legally, distant water fishing in the high seas is not a problem, but it has been an issue for a long time. And what's the problem with the Chinese distant water fishing vessels in these days is it's a different scale. So in the old days, we have this problem. So the Spanish fishing fleet just fish next to Canadian EEZ, and then there caused the disputes between Canada and Spain. So it's nothing new in the 1980s. But nowadays, what we are facing is a totally different, much larger scale of Chinese distant water fishing fleet in the high seas next to the EEZs of many coastal states. So that is something legal, but I think there should be a responsibility there. There should be a responsibility there. So it's not just about balance between the use and protection. I think there should be a responsibility there. And also, we also do need to recognize that fisheries and turtles and marine species, they don't care human-made boundaries. The boundaries are made by human, but if you catch too much in the high seas, then the marine ecosystem will collapse. Also in coastal states EEZ. I think here, this is something I think for the Chinese decision makers, they need to really incorporate the responsibility kind of perspective into their decision making in the future. And when it comes to Belt and Road Initiative, it's the same kind of narrative that I want to emphasize here. It's a good thing. I mean, to be very accurate, the green finance sounds like a good thing, but it really depends how you are going to make it. It could easily become greenwash. And to talk about green finance doesn't really necessarily mean that it will be green in anyhow. And the Belt and Road Initiative is inherently, it is an economic initiative. So how to make sure that the Belt and Road Initiative becomes a green Belt and Road Initiative? That is something I think so far hasn't really